Dakle, sa nama je Marko Del Gaudio, zamjenik nacionalnog tužioca za borbu protiv mafije i terorizma, koji će govoriti o italijanskom modelu konfiskacije prihoda stečenih kriminalnim aktivnostima, posebno protiv organiziranog kriminala, koji se može primijeniti na zločine počinjene od strane javnih službenika protiv javne uprave. Napominjem da Del Gaudio...
We will have to leave us. Mr. Gaudio, you have the floor.
Sì, la sento, buongiorno.
Dobar dan, gospodine Del Gaudio.
Bene, allora buongiorno a tutti dunque, come saprete sono Marco Del Gaudio della Direzione Nazionale Antimafia e Antiterrorismo. Ringrazio molto gli organizzatori per avermi coinvolto in questo meeting. Sono molto dispiaciuto di non poter partecipare a tutti i lavori, ma avevo un precedente impegno che non mi è riuscito di rinviare. Vi domanderete come mai in realtà un magistrato, un pubblico ministero, un prosecutor della Direzione Nazionale Antimafia sia stato in realtà coinvolto per discutere con voi di corruzione e ovviamente della confisca dei proventi del reato secondo il sistema italiano. È una domanda giusta, ma è una domanda che per me è abbastanza semplice da considerare. In realtà negli ultimi anni noi abbiamo assistito ad una sostituzione continua delle forme più eclatanti di violenza attuate dalle criminalità organizzate per controllare il territorio, una sostituzione degli atti di violenza con atti di corruzione, sulla base della circostanza che evidentemente si governa molto meglio il territorio e è possibile ottenere le risorse pubbliche attraverso gli appalti pubblici che vengono attribuiti nel nostro paese. Si governa molto più semplicemente con la corruzione, cercando cioè di portare dalla propria parte i pubblici ufficiali e inserirli in una gestione delle risorse complessiva che viene effettuata dalla criminalità organizzata piuttosto che con la violenza. Le organizzazioni criminali io posso soltanto avvicinarmi, in effetti, ecco, va bene, è meglio? Dunque dicevo, abbiamo assistito in Italia ad una sostituzione sostanzialmente delle attività più violente della criminalità organizzata con una gestione invece delle risorse sul territorio effettuate attraverso gli strumenti della corruzione. Già molti anni fa il collaboratore di giustizia di Cosa Nostra, Angelo Simino, ci spiegò il cosiddetto metodo del tavolino, ossia il fatto che la criminalità organizzata, in quel caso si trattava di Cosa Nostra, ma la stessa attività viene compiuta dalla camorra napoletana o dall''ndrangheta calabrese e dalle altre forme di mafia presenti sul nostro territorio, hanno sostituito la possibilità di ottenere gli appalti con la violenza, cioè allontanando per esempio con la forza i concorrenti dalle gare pubbliche, i concorrenti sgraditi, hanno sostituito questa possibilità con la gestione delle risorse pubbliche attraverso un controllo da parte della criminalità organizzata degli arricchimenti che derivano dalla pubblica amministrazione. In che modo? La mafia si è sempre più proposta come un corpo intermedio, cioè una stanza di compensazione in cui gestire le pretese degli imprenditori di ottenere risorse da parte della pubblica amministrazione, la necessità per alcuni esponenti corrotti della pubblica amministrazione di ottenere il prezzo della corruzione per l'attribuzione di questi appalti e la possibilità per Cosa Nostra, per la Camorra, per l''ndrangheta di ottenere l'attribuzione di queste risorse piazzando negli appalti più lucrosi gli imprenditori appartenenti alla propria organizzazione o comunque quelli a cui dare il proprio favore. In questo modo evidentemente la corruzione è diventata un anello importante nella gestione del territorio e delle risorse. La corruzione è diventata cioè lo strumento attraverso il quale la mafia, attraverso le organizzazioni criminali di tipo mafioso, riescono a gestire il consenso da parte per esempio delle attività imprenditoriali e riescono a gestire la possibilità di ottenere risorse da parte della pubblica amministrazione, riescono a ottenere anche una sorta di welfare per il territorio sul quale operano, perché a questi imprenditori viene spesso richiesto per esempio di assumere soggetti che si rivolgono a Cosa Nostra, alla mafia o alla Camorra per essere assunti all'interno delle proprie imprese. E queste imprese sono evidentemente ben disponibili ad entrare nel gioco e a fornire il supporto perché la criminalità organizzata possa ottenere appalti lucrosi da distribuire poi agli affiliati. Questo settore dunque ha la necessità di, come evidentemente è stato importante per il contrastare le mafie nella loro manifestazione più violenta, ottenere gli strumenti diciamo, di repressione e di controllo particolarmente utili, come per esempio il sistema della collaborazione con la giustizia o la detenzione al carcere speciale, di cui è l'articolo 41 bis nel nostro ordinamento, il cosiddetto carcere duro, anche se in realtà si tratta più che altro di un carcere che impedisce ai esponenti di rilievo dei gruppi criminali di continuare a comandare dal carcere. Dico, come è stato necessario munirsi di strumenti giuridici per quanto riguardava le manifestazioni più eclatanti di violenza, così è stato necessario munirsi di strumenti particolarmente efficaci per contrastare la criminalità organizzata da un punto di vista patrimoniale. E ovviamente se la corruzione rappresenta uno degli strumenti di arricchimento più importanti, è stato importante utilizzare nel nostro ordinamento strumenti che consentissero di aggredire patrimonialmente, da un punto di vista patrimoniale, sia le organizzazioni criminali, sia i soggetti che con queste organizzazioni criminali fanno affari e i soggetti corrotti all'interno della pubblica amministrazione. Pensate che in alcuni territori, ovviamente non parlo necessariamente dei comuni più grandi, ma pensate a tanti piccoli comuni anche della provincia italiana, che pure sono centri di spesa importanti per le risorse pubbliche. Pensate come la criminalità organizzata è riuscita talvolta a inserire all'interno della pubblica amministrazione, dei consigli comunali o della struttura burocratica degli enti pubblici, è riuscita a inserire dei propri affiliati o soggetti che comunque rispondevano alle proprie o rispondono alle proprie indicazioni. Qual è questo strumento? Lo strumento nasce, ed è la confisca essenzialmente dei proventi delittuosi, nasce con queste caratteristiche che vi spiegherò, cerco di essere il più breve possibile, nasce ovviamente soprattutto per i reati di mafia. Ed è una confisca che si fonda su un criterio particolarmente rilevante, cioè direi un allontanamento del cosiddetto requisito della pertinenzialità, cioè del fatto che le somme di denaro che possono essere sottoposte a confisca siano proprio quelle stesse somme di denaro, quegli arricchimenti che sono il prezzo del reato di corruzione o il prezzo del reato di
There
associazione.
was a technical problem. So we have just managed to deal with it. Now I hope that you can understand the English translation.
Un problema per la traduzione.
Znaš šta ću sad uradi?
Fermo un attimo. Ma ti figuri, capisco perfettamente.
Može samo jedna kratka proba. Igore, molim ti, kaži nešto na engleskom jeziku. Samo da vidimo da li to ide gdje treba.
Dicevo, dunque, lo strumento principale che è stato congegnato dalla legislazione italiana è stata la confisca e ovviamente nella fase delle indagini preliminari il sequestro che poi consentirà al momento del dibattimento e della chiusura del processo la confisca definitiva. Confisca che però ha delle caratteristiche particolari. Nasce questo strumento sostanzialmente con la legge del 1991, 356, 91 poi diciamo modificata nel 92, in realtà che segue, è uno dei primi interventi che viene effettuato dopo le stragi della mafia nei confronti proprio dei magistrati che si impegnavano maggiormente nel contrastare. Parlo ovviamente delle stragi di Capaci e di Via D'Amelio relative ai colleghi Falcone e Borsellino. Qual è il punto centrale di questo tipo di confisca? E cioè staccare la possibilità di procedere a confisca degli arricchimenti che sono intervenuti per effetto della partecipazione alle associazioni mafiose dal reato che è stato commesso. È ovviamente importante che sia stato commesso un reato e che questo reato abbia realizzato una somma di denaro o un arricchimento, anche in termini evidentemente non di denaro liquido, ma la confisca e il sequestro potranno intervenire anche sull'equivalente, sull'arricchimento equivalente rispetto a quello ottenuto con la somma, con il reato commesso. Questo significa che non è necessario sottoporre a confisca esattamente il prezzo di quel reato, esattamente quell'immobile per esempio acquistato attraverso il prezzo della corruzione o ottenuto attraverso una estorsione, ma è possibile sottoporre il valore patrimoniale corrispondente procurato nel patrimonio del soggetto che viene indagato anche se appunto è scisso dalla realizzazione immediata del reato. Questo tipo di rivoluzione, perché prima in Italia, ai sensi dell'articolo 240 del nostro codice penale, era sempre necessario che il sequestro e la confisca intervenissero esattamente sul valore patrimoniale, sul denaro, sul bene mobile, sul bene immobile che era stato oggetto, diciamo, del reato. Ma con questa invece modificazione si apre la strada, diciamo, ad una idea della confisca che riguardi esattamente il valore. Consapevole del fatto che mentre la criminalità organizzata, ma devo dire anche i pubblici ufficiali, sono disponibili qualche volta a soffrire le pene del carcere, sono molto meno disponibili a perdere invece il patrimonio accumulato illecitamente. In questo modo poi in Italia sono state ampiamente utilizzate anche le cosiddette misure di prevenzione e poi evidentemente la confisca cosiddetta che noi chiamiamo confisca allargata. una confisca appunto che riguarda l'intero patrimonio del soggetto. Qual è
the concept of extended confiscation? What are the presumptions to have this confiscation? To make distinction between the how to make a good assessment, how to confiscate the property, and whether the property of a suspect is disproportionate to his income. This could be checked according to the tax returns that every citizen files, compared to the effective possibility of that person to make an income. If it takes into consideration an entrepreneur or someone else's case. So this refers to public officials and officials who accumulated wealth that is not proportionate to his or her official income.
Nella consapevolezza che è uno strumento che consente di fronteggiare efficacemente.
Sorry, we had a problem with the sound, so that is why we are interrupting the smooth interpretation. Medo, ja prevodim, stavila sam telefon pod jasne prevodi. Ili problem? Ja prevodim. Aj, čao. Sorry, I'm on again. This is rather stressful, but we'll pick it up from here. So we can apply the same system on legal entities, companies, associations, and so forth that acquired assets and property through offending. So some criminal organizations or connections with the criminal organizations helped some companies acquire wealth, and this could be investigated by application of this system. If a company uses corruption to get a tender, to win a bid, then the Italian system is very good, the system applying to entities, business entities, because we consider it a criminal offense. But if it is not a physical person, we can't arrest a legal entity, and that is why then we can seize the assets. And that is why we establish whether a company, just like a physical person, legal entity, acquired wealth through criminal offense. This is very complex subject matter because the prosecutor has to prove that. to prove that when it comes to commercial growth of and enrichment of them, we could prove that they acquired that in relation to offending, committing criminal offense. So how we go about it? I would say that we've made a cultural revolution in Italy with this instrument, especially from the beginning of 21st century. From 2000 on, the investigations changed. We were clear then that the classical investigation wouldn't be enough. It wasn't enough to apply just classical instruments to go after a criminal who's into hiding and whose property is concealed. So the classical investigations didn't enable that. We didn't prove efficient in proving disproportionate wealth, no matter whether it's physical or legal person. We are after classical investigations, were classical police-led investigations. And what we understood is that we should look into finances, financial flows, and the shares in company, then go after beneficial owners and try to get those information. In classical investigations, you couldn't get this information. So that in Italy, at least in big prosecutorial offices, and I have experience in Napoli, concretely where I used to work, and before I joined the National Directorate in Palermo, we started with investigations running on two tracks. So when the prosecutor started an investigation against some classical mafia organization through wiretapping, seizure of documents, and through statements of witnesses and others, we would look into investments. If we are aware that there were some investments made by the person, we understood that it could be money laundering because they tried to legalize money. In classical investigations, would come up with that information. We would start parallel investigation conducted by financial police, who are specialists, who have expertise and technical knowledge to understand those processes and to start parallel investigation in order to fight against the crime also from financial angle, in order to detect and prosecute all kinds of predicate offenses like drug smuggling and else. So we worked side by side with financial police. So if we have people who work in the system and they supply information and influence and act as mediators to those criminals, so we would also conduct parallel prosecutorial investigation, but also we look into elements to compile information and to start financial investigation of the property that person owns. And that is how we managed to score important results. So it is very important to have investigation of this kind, and what we found that we have classical criminal investigation, the classical police investigation, but also side by side financial one to complete. And to supply necessary elements for indictment and charges. Financial prosecution and financial investigation is important in order to seize disproportionate property, to seize and confiscate the proceeds of crime with certain economic and owing to the financial and economic expertise and knowledge of people who work with us, as to enable first seizure and then final confiscation of those proceeds. It is very important and it was very important in our context that we fought money laundering, and money laundering is about how to start investigations hand in hand, meaning classical prosecutorial together with financial investigation. So this awareness that investigations are not only about arresting offenders, they are to also aimed equally at seizing their illegal assets. And then it is a bigger shot to enable judges to build a case, so to say, for charges, for convictions and seizure. So there are also third parties who actually assisted by offering financial or commercial services, and who nominally don't go by those obvious criminal elements, are not at first look don't look like criminals, but their role is very delicate, and we need a delicate operation to go after them. So this is a very important activity, and we acquired each competencies. We started to better understand. We better understood then, and afterwards how it's handled, and we better understood all the intricacies of the crime committed. I will stop here, but you will have some other speakers after me, prominent speakers who will be able to explain to me how they went about that in their jurisdictions. I believe we are limited with time anyway. I believe I've explained my point, and I want to thank you for inviting me. I didn't manage to explain all, but however, I hope I managed to present my views. I'm ready to submit my intervention in paper, if you wish. And I want to say that I'm also ready there to explain the issue in greater detail in technical terms as well. which is not possible here and in such a short time. I want to thank you once again.
Thank you, Mr. Gaudio, for this exhaustive presentation. Now we'll have here the German experience, Dr. Van Rupert, head of the section for the Southeastern Europe, German Foundation for International Legal Cooperation. You have the floor.
Thank you very much. Hopefully I'm visible and hearable now. Dobar dan. Ja ću biti veoma kratko, jer znam da smo već prekoračili vreme. Meni je drago da slušam i...
And I'm hearing the English translation. I'm pleased that I can speak on behalf of the Foundation for International Legal Cooperation, which works or functions within the German Federal Republic and with the funds of the German Ministry of Foreign Affairs. And I will present Dr. Greier, who is the High Prosecutor, but he's also a prominent author of a book on confiscation of assets. He was also an expert in international projects, FARE, Romania, Taiwan, and a guest professor at the University of Köln. So he has practical and theoretical experience, and he will now present the German experience. And he will tell us directly something about the topic. Dr. Greier, you have the floor.
No, thank you very much. Thank you for having me. I hope that you can hear me and see me. First of all, I would like to start thanking for the invitation. I have to say I'm really impressed by the discussion that we have heard this morning and just from the Italian colleague a couple of minutes ago. Really impressive how profound your discussions are already. And I think you're on a good way to find some legal solutions to your problems. What I would like to point out is basically three issues, which would be what are the basic principles governing the German legal system, our law in this area of confiscation. I would like to point out something about the evolution. It's not a revolution, it's rather evolution in the German legal system over the last years. And I would like to end with, I would like to call it lessons learned. So maybe you can, we can prevent that you make the same mistake that we have made over the years. To start with, the German law has some basic principles like any other legal system. And one, of course, is that the confiscation is a basic pillar. It's nothing new. We've had confiscation regulations in the Roman law in medieval times, and crime shouldn't pay. It's such an obvious formula that anyone should know it who has ever had involvement in criminal investigations. But the question is always, how do you transfer this into national law? As it varies from nation to nation, I would just like to point out some issues concerning the German law. First of all, it's a constitutional question, of course. Property, the right to property is always involved here when we talk about confiscation. And on the German law, the German Constitutional Court held it numerous times that the aim of confiscation is not to sentence. So unlike imprisonment, or if you have to pay a fine as a sentence, the confiscation is rather considered as a way, as a means to revoke a previous illegal shift of assets. Simple example, you have a thief, takes €1,000 from a victim. That obviously is a crime, and it's at the same time, of course, it shifts assets, €1,000 from the victim to the thief. And confiscation should be there to reverse this shift and not to sentence somebody, which means that certain legal regulations that are applicable to a sentence are not applicable to confiscation. We still have the rule of proportionality, of course, but it does not exist in the same way. If you gain a proceed of €1 million from a criminal act, but you don't have it at the end of the day, that doesn't matter. It's your personal problem, and it's a problem of execution. But it's not that you have to say, well, the sentence has to fit the crime. The sentence doesn't have to fit the amount that will be confiscated. And this has a direct impact on the options for confiscation. We can only confiscate the amount that was originally gained through the criminal act or for the criminal act. That's easy in the example with the thief, but it gets more complicated if you have, for example, a bribery case. Someone bribes an official to make sure that a contract will be awarded to a company held by a friend in Malta with the company shares held in the Isle of Guernsey or Man or whatever. Next question is, how are you allowed to deduct a certain amount of money? You have to pay for the Maltese company. You have to pay for a road that was subject to the bribe-connected contract. Can you deduct this if it's just reversing a shift of assets? These issues are, under German law, quite ambitious to solve. We have these as issues. We have numerous decisions by the courts, but not really a clear solution. But it's based on the pillar that it is just a reverse of a shift of assets. Another important issue is victims' rights. The victims' rights are always important in these contexts because we are, as we have just pointed out, obliged to reverse the shift of asset back to the victim. You do have a problem if the victim does not cooperate or doesn't want to have his money back for some reason or another, or you don't have a victim. In drug-related cases, you don't have a victim. Still, you can confiscate the money, of course. But as soon as there is a victim, it gets more complicated because another basic principle is that if you want to reverse a shift of asset, you can do it only once. We cannot take the money away from the thief, 1,000 euro, if he had already paid the money back to the victim, because that would be somewhat a double claim against the defendant, and that is not allowed under German law because of, as I just pointed out, we just have to reverse the shift of assets. And that brings us to other problems. We have to ask a question, what if the victim and the criminal, they reach an agreement for some reason or another, sometimes an enforced agreement, sometimes an agreement that actually is out of free will, and the victim settles for 500 euros. So if the victim is compensated and he says, I'm fine with 500 euros because the criminal doesn't have any more, does the crime pay? Are we allowed to get hold of the rest 500? Because we wouldn't be making him pay twice. Depending on the legal situations, you have this or this answer. Currently under German law, that would be it. You can keep the rest of the 500 euros if you're a little smart as a criminal. Another principle that I just shortly like to point out is the principle of legality. That's what we call it in the German law, meaning we cannot select the cases that we prosecute. If there is a case, if we have enough evidence to open up an investigation, then this is our legal obligation as prosecutors to do it, and we do it. So it's not that we can select the cases and start an investigation here and skip an investigation on the other hand. If the case does have sufficient evidence, we will have to open it and, of course, have to look at all the financial aspects of a case. And it is very important to always keep in mind that we do not have the option of, I think Dutch law has it here or there, that we can maybe skip one area or another.
Gospodine Greier, kakav je uticaj...
Mr. Greier, what is the influence of the European legislation or the decision of the European Court on the German legal system and your solutions?
Yeah, that's quite a big issue because we pointed this out this morning in the first panel that you've had, that the European regulations, meaning EU or European Council, have quite an impact. On the European level, just as on the international level, there is almost the protection of property. We have it in the German Constitution, Article 14. We have it Article 17, I guess, in the basic rights charter of the European Union, and we have it in the European Convention for Human Rights as well. And we, of course, have to monitor the jurisdiction that comes from the ECHR. The UCOS case was one that was quite important to preliminary measures in this area. And we have to see that the European Union, just as the European Council, both are very active in the area of victim rights. There's a tendency in the last decade probably that the rights of victims were always put more in the focus. And another issue that's quite important in both areas, EU and DC, is anti-money laundering. And we should never, it was, I guess, what my Italian colleague before said, we should never forget the importance of a proper anti-money laundering system in fighting corruption, fighting financial crimes, and in confiscating assets, because the sources to gain knowledge about financial transaction are various, but all those reports by those who are obliged to report under the anti-money laundering regulations on the European level are very valuable. So it's important, yes.
Još jedno pitanje, dakle, iz vašeg...
Another question, from on your own experience, how important it is to establish special teams, because we are in the transitional period where it is necessary to have the distribution of justice properly after 30 years of lack of any judicial epilogues. And we need to concentrate on some specific cases or on the people who have high profiles and who are very important in the society, in the country, and who maybe, but who potentially participated in these kinds of activities.
We have tried to concentrate certain cases, high-profile cases with large damages, for example, with huge assets to be recovered, in a certain special unit. But to be quite honest, it didn't work. We have, as you know, a federal system in Germany. We have 16 states making up the Federal Republic of Germany. North Rhine-Westphalia, the home state that I come from, is not the biggest. Bavaria is a little bigger, but the most populous state is North Rhine-Westphalia. So we have quite the resources actually to try this concentration. We did it, but maybe this always is an aspect of lessons learned, but we've tried to make it more an advisory body. You could call the colleagues there, they were highly qualified, they knew all the tricks. You could call them if you had a difficult case and ask them for advice, but they did not actually take the cases. They could have, but it wasn't wanted, there was not the political will maybe to concentrate the cases there. So we keep the cases with the local public prosecutor's office. In Cologne, we have a little more than 200 prosecutors, so we have the option to specialize. We have specialized colleagues. I was one of those specializing in question of confiscation. We have the option to do this, but of course I see that just like the smaller states in Germany, maybe Montenegro does not have these options. So to start with and to get it going, I think it is important to get some expert together, and if the legal system in Montenegro offers this opportunity, to maybe assign those cases to a group specialized in this area. And that should be, of course, people knowing the tax regulations, because it's always important to take a look at the tax files to know which tax details you might include in a criminal investigation, which you might not. Police officers, forensic experts, and cyber. We have a special cyber unit here. They often help us talk about cryptocurrency. This is an issue that is getting more and more important. And of course, prosecutors under German law, the prosecutor is in charge of the investigation, the preliminary investigation. So to bring them all together would be the best way. We are not doing this. Maybe this is an explanation why we're not that successful in some cases. But I think that it's also important for a long-term strategy to get everybody, each and every prosecutor, each and every police officer in the country to know the rules, the plain vanilla cases, the simple cases. If you work on these cases and they actually work, you succeed, then you get experience and then you get the trust to go on the bigger cases. And that is always difficult to do just by training. So experience is important. If you have some experience, it's easier to go for the high-profile cases. I hope this answers your question.
Hvala vam na učešću I hvala vam na...
Thank you for your participation and your presentation of your precious experience and suggestion. And now it's the time to refer to Mr. Rupert Vining from the UK. He's expert in the rule of law and fights against organized crime and corruption. Hello, Mr. Vining. We hope you can hear us.
I can hear you. Hopefully you can hear me.
Čujemo vas odlično.
Can you hear me?
Odlično. Čujemo vas. Izvolite.
Can you hear me?
Čujem odlično.
Yes, we can hear you. I can hear you. Everything's okay. Is everything okay with you?
Are you able to hear me?
Yes, yes, we can hear you.
Well, I appear not to be having any interaction. Up your messages on chat, and I will take it from there if there's difficulty, and doubtless Mariana will assist. Firstly, thank you for inviting me to speak today on partly the UK experience concerning confiscation and the proceeds of crime. I am, in fact, a UK Crown advocate, but I should point out to you that what I say today is not on behalf of the Crown Prosecution Service, but simply my experience working within the region of Southeast Europe, and in particular in Montenegro, and applying the legal knowledge and experience I have. I listened with interest to Dr. Greier's description of the position in Germany. I think that the UK regime is slightly more aggressive than the German regime. He may correct me on points of detail. Our system uses the same theory that the German system appears to use. That is that confiscation is not a punishment, it is reimbursement of what should not have belonged to the suspect in the first place, and is obtained via their offending or as a benefit via their offending. And here I think the difference may be a little more plain. In the UK, it is possible to have an extended regime of confiscation that goes beyond the mere conduct of the offence itself and is termed as a lifestyle offence. If you are convicted of a specified category of offences, which could include bribery, could include possession with intent to supply drugs, you are made liable to extended confiscation, the so-called lifestyle offences. In that case, the state makes the presumption that all assets in a previous period of years that you have in your possession is the product of your criminality. And it is for you as the suspect to disprove that you acquired that material through criminality. This, in large part, I would describe as in rem confiscation. Using Dr. Greier's list, victims' rights, yes, confiscation can be diverted to a victim if need be. And yes, we are careful to avoid double claims. No, we do not apply the legality principle in the UK. We operate under a prosecutorial code test, which requires a test of sufficiency of evidence and of it being in the public interest. For the purposes of this quick discussion, in the public interest means that it is right to prosecute. Therefore, we are not obliged to prosecute in the same way that Mr. Dr. Greier or his colleagues would be required to do. Dr. Greier raises the impact of the judgment. I had the privilege to advise in Montenegro the then Deputy Prime Minister on the notion of unexplained wealth and illicit enrichment. And I was able to show in the paper I produced, which I think Mans has a copy of, that UK legislation, which, although aggressive, has been adjudged to be compliant with the European Court of Human Rights and the European Convention on Human Rights. And indeed, that included, for example, the reverse burden of proof, which is integral to the offence of unexplained wealth. I am interested in Dr. Greier's point about capacity in Montenegro to deal with notions of confiscation and unexplained wealth. It is a highly specialized subject, and whilst the UK does have powerful legislation, the success rate with our Proceeds of Crime Act and indeed with the Unexplained Wealth Order that came into effect in 2017 has been particularly difficult around the issues of third-party ownership of assets, and that becomes even more difficult where you're dealing with the Unexplained Wealth Order. In my view, Montenegro should not necessarily take off-the-shelf legislation that is used in Western Europe. Our resources are greater than Montenegro's, for instance, in the UK, doubtless in the Federal Republic of Germany. What Montenegro needs is something that is practical and usable by ordinary prosecutors. By all means, have a specialized unit for reference and expertise, but above all, make any legislation that is introduced into Montenegro user-friendly for prosecutors and financial analysts. Financial analysis is a very difficult, challenging subject, and the higher value the potential claim, the greater resistance you are likely to get from highly skilled lawyers who argue that the defendant's possession or the defendant's family's possession of assets is genuine and should not be challenged. So, although I am not asked to do it in this segment, I have been asked to advise Montenegro at high level previously, and indeed offer government level advice across the region. My emphatic advice is by all means build expertise, possibly concentrate expertise in an advisory capacity, but do not make a direct import of legislation which implies all the resources that the United Kingdom or, for example, the Federal Republic of Germany would have, or indeed the Republic of Italy. It simply is beyond Montenegro's capacity, in my view, to use. As I say, I did offer government level advice to, he was then, I think, Deputy Prime Minister Markovic, and in the end that legislation was not progressed with. I understand my colleagues from the UK are proposing a different form of confiscation, and I wish them success with that, and if time permits today, I will listen to their presentation later. At this point, I would invite any questions anyone has in relation to what I've talked about.
Je li ima nekih konkretnih pitanja? Dobro, predlažem, zahvaljujem se gospodinu Viningu.
Thank you, Mr. Vining. Now we will proceed with Claudio Valentini, Unit for Preventive Investigations from Unit for Fighting Mafia from Italy.
Dobar dan, gospodine Valentini. Izvolite.
Buongiorno, mi sentite?
Dobar dan, čujemo se, izvolite.
Ok, dobar dan svime. Io sono il colonnello Roberto Dieghi,
Hi. Hi. She from the Preventive Investigation Unit from Anti-Mafia Investigative Directorate, cooperated with you. We've been using this model for quite a while. I come from the Office of Foreign Affairs, which also has internal affairs, which also has this department, financial police and classical police. So we have the task to fight mafia in Italy. As my our friend, Mr. Prosecutor Gaudio mentioned, our mafia organizations developed in such a way that all that we had to develop, that in Italy we had to develop the system in such a way that we have parallel investigations. So now we even have preventive investigations, which are very important in fight against mafia. So they are very effective, even more effective than judicial investigations. We want to hit them hard and hit them on property. This was proven to be the most efficient form of fight against mafia. Preventive activity is based on a couple of aspects. Preventive measures that I will reflect upon today. Fight against money laundering through analysis of suspicious financial operations. Again, a very important instrument. And prevention and fight of against infiltration of mafia organizations into big public tenders. So funded mostly by the EU money. So this is a very interesting trade for mafia organizations. So today we have silent mafia, which was mentioned by prosecutor. Mafia is not so visible any longer with killings and violence in the streets. What they try to do is to recycle or launder and legalize illegally acquired property, proceeds of crime, mostly coming from the smuggling of drugs, not only from there. We use preventive measures because we want to preempt those cases. And that is why I'll give the floor to my colleague, Claudio Valentini, who comes from the financial police, and who is a member of this team who works on preventive investigation in our directorate, anti-mafia directorate. Hi, everyone. Within as a part of preventive activities, I make assessments on indirect and direct suspicions, presumptions about measures that operational centers of Guardia di Finanza could do. We have our outposts throughout Italy. So they give us information in order to do the preventive investigation. So it was short. Targeting property has always been very important when it comes to the investigations and prosecutions and policing. work saw the militant power of mafia organizations, and their power in the field is a part of the universe of mafia work. What worries us is the capacity of mafia organizations to penetrate into the economic tissue of a country, and these in this the tenders are most vulnerable in this regard. I mean, so through that they managed to accumulate lots of funds, and what mafia is about is to legalize illegal money, to spin it over into ostensibly legal economic activity. What is important first is to have legislative framework. Concretely speaking, we have to have the measures in place that will enable to make assessment of illegal property and then connect it, trace it back to where it came from. So our goal was to target the criminal organizations and their capacity of controlling the territory, and that we do that in preventive measures of personal character, and you'll see later which these are. These are the measures that limit the personal freedom of a subject when it comes to financial aspects of mafia work. They have some power, they command power, and it's very important to take the property proceeds from them whenever we anytime we prove that it comes from illegal sources. Legislation regarding preventive measures is a part of norms related to fights against organized crime. It is about, and it is a legal procedure, it is a judicial procedure that works on anticipatory basis. So you don't need to establish the existence of offense or the facts of it, and we can start an activity based on indications only. So what are characteristics of and procedures that we use in prevention compared to criminal proceedings? So there are two autonomous procedures when it comes to how it works. Preventive investigations are focused on examining or establishing social danger that an entity presents for the society, I mean, whereas criminal one has to prove criminal offense and criminal accountability of a subject. Between these two proceedings, as prosecutor Gaudio said, we have this twin track approach. We have the law, anti-mafia law, that enables the autonomy. It gives and bestows autonomy on both of these, so each can run autonomously, so criminal and proceedings related to preventive or asset seizure part. So we have criminal proceedings aiming at establishing the criminal offense and repression, and it can lead to criminal seizure, so that we could take away, that we could seize property that has been acquired through that criminal offense, while preventive one aims at establishing a social threat that such a subject becomes. And we can determine that even in the absence of criminal offense, and what's then confirmed through establishing or proving the criminal offense. Preventive proceedings, that if we compare it to criminal offense in classical terms, has judicial character, which is to say that these procedures are applied and used by, run by judicial authorities. It has procedural characteristics that are similar to criminal proceedings, where you have the right to defend yourself, to adversary proceedings, you hear all parties involved. However, when it comes to its final outcome, it is the process, through this process, that we could, for example, take away documents, seize the documents and papers, and other things that that are issued or given to those people who they possess, which they possess. So, when given all the norms that apply to this, we envisage that the entities such as police and prosecutors could suggest that. So we have the director of anti-mafia directorate can and has the mandate such the same as minister, the director of police have equivalent competencies, and they can order the procedure to start. The same is that the prosecutors and judiciary can ask that, legislator wanted to distinguish between different social threats, threats to society. If it is qualified social threat, then it is the judiciary body that is in charge of ordering this proceeding. So those could be anti-mafia prosecutors, and if they establish then the social threat of regional standing, then we have the district prosecutors getting involved. So we can run locally, regionally, and at national level. What are the presumptions for application of preventive measures? We mentioned this social threat, that this subject, that this person is. So in preventive measures, you don't need to have this social threat or social jeopardy proved. So it is very important that this measure is ordered at the moment when the property is there and at disposal, and we could start our preventive investigation. The value of the property that we are to confiscate has to be such as to be disproportionate to the material and economic capacities that that person or that subject commands. So we have to prove that this property is a result of some illegal activity then. There are alternatives. So we have to have those alternatives. So we should find two things, either disproportion or indications that certain property was acquired through criminal activity. Depending on how dangerous are for a society. So these are subjects or entities who are very dangerous in general terms. Also, the anti-mafia law defines a whole series, whole string of criminal offenses that are within the jurisdiction of territorial, of the unit, anti-mafia unit covering that territory. It is Article 416 of our criminal code, where we have mafia members, camera members, so then people assisting them, then prostitutes, drug dealers, those who are associated in order to smuggle narcotics and drugs. So these are the serious criminal offenses that fall within the jurisdiction of this department. So we can order preventive property measures, and which is the discipline necessary to apply. So we should start property investigations, and Gaudio spoke about that. They are absolutely necessary in order to have the directorate, the anti-mafia directorate or police order. So they are necessary for those to order the process to establish what the property of that person is. So we analyze and examine the lifestyle of a person's subjective and objective profile, both. We look at the lifestyle of that person, we look at the tax filings compared to what he possesses and has at disposal. So whether he owns yachts, or he bets at horse races and so on and so forth. What are the financial means he or she disposes of? We can also analyze the accounts, and we can examine the records of all the property that person has. So disposal of property could be direct or indirect as the law prescribes. So it is not necessary that that person is a formal owner, because in most cases, almost all cases, that is not the beneficial owner. And that is why we check on persons who live in the same home or lived in the same home with that person anytime within last within 5 years time. So we check all of them who have lived with that person in the last 5 years, and if we establish some disproportionate lifestyle compared to the property. So what financial police does when we have the preventive activities of this kind, we look at all elements. We make a kind of snapshot of that person, what he or she engaged into so far, which offenses, activities, and so. We use a lot the databases and try to profile a person. And then we try to make sure that we map all the connections that the person has. And then we compare it to against the property they do possess, in order to get an idea based on, in order to establish whether the person took part in, for example, bids as well. We try to look at the evolvement, if you wish, of the acquiring process, how and what he acquired over time. Was it purchased at the moment when that person was considered dangerous for the society? And this is one of the elements that make this social threat or threat to society that we deal with at investigation. So so some indications or presumptions are enough for us to start the proceedings, to connect that with the organized crime organizations and individuals. The second path of investigation is following. We file to the competent court on information, and after that what we do with the property, it becomes the possession. It gets becomes a property of the state, and it is managed by our national agency for confiscated property. This would be really a snapshot as overview of our system for confiscation. Thank you very much for your cooperation. I want to add just this, that in this presentation we reduced lots or left out lots of things. You can just imagine that this activity, especially activity focused on proving the accumulated property, and the fact that property is a result of the criminal offense, is very complex. And after so many experience, I want to tell you that this preventive investigation and financial investigation is much more difficult than the classical one. So when it comes to this topic, we tried our best to present the stuff. I don't know if we managed. I would like to add that even if when it comes to Interpol and connections that we have, You can lodge all kinds of requests, formal, informal, question, you can ask for clarification of some aspect, and we are more than happy to do what you request.
Thank you. Now we'll have several minute break and then